to Patrick Shepard. Thank you. You may begin.
Good morning and welcome to our Public Financial Disclosure Massive Open Online course. My name is Patrick Shepard. We are very fortunate today to be joined by Mark Stewart from OGE's Compliance Division. Mark is a very experienced reviewer of public financial disclosure reports and will be taking you through today's 3-hour presentation. We realize that 3 hours is a large block of information, and so for the benefit of our viewers and listeners, and also I think for Mark's benefit, we are going to be taking a couple of breaks today. So welcome, Mark. Thank you for joining us.
My pleasure. Thank you, Patrick.
So today is the first in 2 sessions of our Massive Open Online course. So we hope you will enjoy today's presentation. If you need to take a break, and you miss a section, that's fine, as this recording, like all of our Institute for Ethics and Government recordings, will be available for viewing immediately upon the conclusion of the broadcast today at youtube.com/OGE Institute. And we'll be back here again tomorrow at 11 a.m. for the exercise portion of the Massive Open Online course. So we hope this is a good resource for you. We hope you get a lot out of today's presentation and the exercise tomorrow. So Mark, shall I pull up your slides so we can just get into it?
Yes, please. That'd be great. Okay. Once again, good morning and welcome to the Office of Government Ethics Massive Open Online course on the fundamentals of public financial disclosure. This is going to be an entry-level course for people who are new to the financial disclosure process and to federal government ethics in general. As Patrick said, my name is Mark Stewart. I currently work in the compliance division here at OGE, and I'll be the presenter. A little bit about me. I've been at OGE for, incredibly enough, about 12 years. But before that, I was a Coast Guard attorney. I retired back in 2003. I had a few tours in general law branches, and I actually worked on ethics issues there, including financial disclosure as collateral duties. So I like to say that I've seen it from the agency side as well as the OGE side. Okay, let's talk a little bit of housekeeping. And this course, as Patrick indicated, will be in a lecture format, and it'll take about 3 hours. We will take a couple breaks, mostly for my voice. Then you will have an exercise to review on your time, and we will debrief it tomorrow and take any questions that you have tomorrow as well. Also, just as a side issue, please remember the fundamentals session on the new public financial disclosure guide at 2 p.m. Tomorrow on Thursday, because quite frankly, I plan on attending that one myself, and I think it would be a really good resource, especially for new reviewers.
So we're really giving people a lot to sort of digest during this filing season. And I think we're also going to dedicate the Advanced Practitioner Series next week to public financial disclosure topics. Oh. So lots of opportunities.
Okay, great, great. Once again, please save any questions for tomorrow. And also, if you just need to take a break and I haven't set one up, please just feel free to do so. I won't even know. If there's an issue with my voice or anything like that, they have a call-in number. Isn't that correct?
I'll be monitoring you.
Okay.
So if we have trouble hearing you, we'll make sure to let you know.
Great, great. Okay, let's make sure everybody has the same materials. You should have a copy of the PowerPoint that you're looking at right now, and I hope you printed that off on the 3-slide with notes just to save some paper. You should also have a copy of the 278E form. That form just has some data on it as well. The data will be used for our exercise, but by all means, if you want to take any notes or make any notices as we go through the training, that's great, because this isn't going to be an exam type of exercise. This is just going to be this is where you need to go to learn or find out information sort of exercise. You should also have a handout that says these charts map the OGE Form 278 to the new OGE Form 278E. And you should also have a handout that says SF 278 schedules and applicable reporting periods. And we're going to go over all this later. Okay, let's go to, oh, thank you. Let's talk about the objectives of this training session. If you are here, you are probably newly designated as a financial disclosure reviewer at your agency, and presumably you do not know much about financial disclosure or ethics in general. Welcome. Hopefully this course will help you get started. We will briefly discuss the purposes of financial disclosure. Basically, public service is a public trust, and federal government employees are held to a higher standard. As part of this, certain employees, because of their duties and responsibilities, are required to disclose certain personal financial holdings and outside positions on a 278 form. As for the process, that form must be reviewed and certified by the agency. We will review the form and its parts. We will go over the information that is technically required to be reported, and we will also look at the basic conflict of interest issues. We will look at the basic technical and conflict of interest issues only. You will need to familiarize yourself with more specific requirements as you actually do your reviews at your agency. So our main goal is to give you the basics and also give you an exposure to the resources that you can use during your reviews. As Patrick indicated, we are going to throw a lot at you, and you will not leave here knowing everything about financial disclosure. For subsequent questions, I'd recommend that you contact your agency supervisors or your OGE desk officer.
I'd just like to take this opportunity to remind folks that this will be available as a reference. You know, I think with some of these longer lectures, it can be difficult to digest it all in one, but because it's recorded, if it's more convenient for you to chunk it up, we encourage you to do so.
Okay, let's talk about the legal basis for your review. Before you begin your initial review and certification process, you must make sure that you're familiar with the conflict of interest statutes, OGE's regulations, and any particular requirements that your agency may have. 18 U.S.C. 201 through 209 are the conflict of interest statutes, and these are criminal codes. People can and have gone to jail for violating them. OGE's financial disclosure regulations are at 5 CFR Part 2634 and Part 2640, and they are the specific requirements for both the 278 and the 450 procedures. I did not include them in your materials, but I recommend that you actually take the time to read them, as they are good guidance as regulations go. They have examples and notes and things like that. They're actually designed for the filer, him or herself, to go to for guidance. But I recommend, once again, that you make yourself familiar with them. As for 2640, these are on the conflict of interest and exemptions. And once again, I recommend that you read them. 2635 are the standards of conduct. Every federal government employee has to review them when they are brought onto federal government service. Everybody immediately forgets about them, but you as reviewers need to be more familiar with them. Some agencies have supplemental regulations or other requirements, and hopefully you know that already. Basically, you will need to be familiar with the rules and regulations in order to review and certify financial disclosure reports. Now, we're going to go over these briefly, but if a question comes up, you will probably have to do some specific research. Okay, so let's take a look at the conflict of interest statutes. Once again, basically, public service is a public trust, and as federal government employees, we are all held to a higher standard, not just filers, all federal government employees. Throughout American history, there have been political scandals, et cetera, and after they happen, an outraged Congress would usually draft a statute forbidding a certain behavior that had usually been done by them. Back in 1962, Congress recodified all of those criminal statutes at 18 U.S.C. Once again, they apply to all of us, whether we are filers or not. Let's take a quick look. 18 U.S.C. 201 essentially makes it illegal to accept a bribe in exchange for an official action. We're probably not that concerned with that one. Our goal is to keep honest people honest, to avoid unintentional errors. If somebody wants to take a bribe, they're probably not going to report it anyway. So we don't need to worry about that one as much. Let's talk now about 203 and 205. Essentially, these are representational statutes, and they make it illegal to represent an outside entity back to the federal government. And once again, this can happen with the best of intentions. Back when I was in the Coast Guard, I had a junior officer who had this great idea. He was from a small town on the Mississippi River that actually had a Coast Guard cutter left over from World War II as a floating museum. Unfortunately, a flood came and washed it away. He wanted to set up a corporation or particular entity to refloat it and reset it up as a floating museum. Best of intentions, we got the outside permissions for that. Everything was all set up, and then he was walking out of my office and he said, great, now I can write that letter to XYZ agency to try to get the funding for this. Now, it was my fault. I obviously hadn't briefed him completely, but I had to haul him back in and said, you can't sign that letter representing an outside entity to the federal government to try to get money. Okay. Once again, best of intentions, but could have got him in a lot of trouble. Let's take a look at 207. This is post-employment representation. Once people leave the federal government, there are certain limits on them on what they can do to reach back to the federal government. In fact, once again, I have a Coast Guard story about a retired contracting official who went to work for a contractor and wanted to come on base to be with that contractor to argue for renewal of the contract. And my boss at the time said, if he shows up at the gate, have him shot. And, you know, we're the Coast Guard. We don't normally do that. But those statutes can be very, very particular. And having that person in the room with everybody that he used to supervise when they're negotiating a new contract or a contract renewal would have been a violation of 207. Let's jump ahead to 209, which is the supplementation of salary. Essentially, federal government employees can only be paid by the federal government for performing their federal government duties. Now, you wouldn't think that would be much of a problem, and it usually isn't, but it can come up. A couple of years ago, there was somebody working for the Bureau of Mines out in the western part of the country, and his job was to write memos concerning the payment for people who had licenses to use federal government land for mining and things like that. It turned out that the federal government was undercharging some people. It turned into a lawsuit, and at the end of the lawsuit, the outside entities made a lot of money, not the licensing ones. And so they decided to give our federal government employer a good civil servant award, but they didn't give him just a plaque. They gave him about $380,000. So you can imagine that when the Department of Justice found out about that, they decided that that was kind of a big deal. And as far as I know, that one is still in litigation. Okay, the next one that we need to focus on is our big conflict of interest statute, 18 U.S.C. 208. And I'd like to just read through it with you. And this is, once again, just the synopsis, not the actual statute. But it bars an employee, including a special government employee. And if your agency has special government employees, you probably already know about them. Those are people who are brought in part-time, usually because of their expertise to sit on committees or give advice or things like that, as opposed to full-time government employees like us. From participating personally and substantially in an official capacity in any particular government matter that would have a direct and predictable effect on his own or his imputed financial interests. So once again, what we're saying here is that as federal government employees, we can't take federal government actions that assist our own assist our own financial interests. it's just against the law for us to do that. But if you read that whole thing through, you see there are a lot of particularities in there that need to be either proven or not proven to have a cause under 208. We're not going to go into the details on that, but if you're going to be dealing with financial disclosure, federal government ethics, etc., you're going to have to know a lot about the basic concept of a conflict of interest. All right, I want to tell another quick story about 18 U.S.C. 208 just to show you how somebody can inadvertently get into trouble with it. Back in the Reagan administration, a civilian businessman named Marvin Runyon was brought into federal government service because of his business acumen. Fine, that's great. At a subsequent point, he was made the Postmaster General. Once again, that's fine, that's great. He's a wealthy businessman, he has lots of holdings, but probably none of them have anything to do with the Postal Service. Well, one of his official actions was he had the idea to partner up the Postal Service with businesses. And one of his ideas was to have a soda machine inside every post office, but not just any soda machine, a Coca-Cola machine. And he took official action. He ran meetings, he wrote memos. He said, unfortunately for him specifically, Coca-Cola machines. Well, he happened to have Coca-Cola stock. And when the word went out that this is what he was going to do with the Postal Service, the value of that stock went up, including his shares. We're going to talk more about this later, but if there's an actual conflict of interest like that, it has to be investigated by your agency IG, and it has to be referred to the Department of Justice. Only the Department of Justice can decline prosecution, and in this case, they did not decline to prosecute. They sued him. It was, quite frankly, a perfect paperwork case. And as he said at the time, he didn't join the federal government service to make money. He was already a very, very wealthy man, but the value of the stock had gone up based on his official actions. He was sued, he had to settle. It was a big embarrassment all the way around. And when he passed away, that was also mentioned as a part of his legacy. And we want to avoid that for our filers. Okay, let's talk a little bit about the Office of Government Ethics. In spite of those new statutes back in 1962, it turned out that there were still new scandals and other ethical lapses in the federal government. So right after the Watergate era, back in 1978, Congress created us. They also created the concept of the Public Financial Disclosure Form, or the 278 at the same time. There had been prior executive orders on financial disclosure at the agency level. Some did it on their own. However, agencies were not really reviewing and certifying the forms and resolving any issues. Congress wanted a uniform report for all filers and thought it was appropriate to have it releasable to the public. And if you look at old newspapers from back in the day, you would have thought that the entire executive branch was going to resign out of horror and disgust rather than fill out that form. The Ethics Reform Act of 1989 made OGE an independent agency. However, we're just an oversight agency. We don't do any real investigative work or anything like that. We do the regulations and we give guidance. So each agency is responsible for its own ethics program under its own designated agency ethics official. One original thought back in 1978 was to have a huge OGE to control all executive branch ethics, but ethics issues are very fact specific and can really only be monitored at the local office level. And even then, it's difficult to keep up with it as situations can be fluid. But hopefully, your agency employees are trained and are open to a relationship with your office. Now back to OGE. The main purpose of your agency ethics program is to help agency employees avoid conflicts of interest. So between the OGE regs, our desk officer program, our agency reviews, and you as agency ethics officials, we are in a relatively good position to keep our employees out of ethical trouble and focused on their work. Okay, back to financial disclosure. Basically, it ensures employees avoid conflicts of interest. Our job is to review the report and compare it to the filer's holdings and their duties, and therefore check for conflicts of interest. Once again, we're keeping honest people honest. We want to keep them from inadvertently getting into trouble. And we need to have our background information so that we can do that part of the job. We're going to focus mostly on the mechanics of the form again, but if you see something that you think is a potential conflict of interest, you have to dig into it. And once again, if a filer has a financial holding that could be affected by his or her work, but has not taken any official action, then we have a potential conflict of interest. This is what we hope for, because if we spot that before the filer takes any action, then we can get it resolved. However, if our filer has taken an official agency action and it impacted his or her financial holdings, kind of like our Marvin Runyon, then it's an actual conflict of interest. It has to be investigated by your IG and referred to the Department of Justice. Other reasons for having a agency program, concepts of transparency, confidence, and maybe should keep some people out of federal government service. But that's a conversation for later. Okay, who are our public filers? There are certain employees, because of their positions and responsibilities, are presumed to have a higher risk of a conflict of interest. The statute defines who has to file a 278. Generally, it's employees above the GS 15 level. So essentially, it's our SES types. And this is just an FYI. OGE also regulates a confidential financial disclosure process for less senior federal employees, and that uses the OGE 450 form. We have entire other courses on that. Okay, let's talk about your agency's 278 certification process. As part of your agency ethics program, you have to have a written certification process by which you determine who must file the 278, how to collect, review, and certify those 278s, and then maintain those reports. Now, basically, the filers are responsible for filling out and submitting the form, but the agency's process must include at least a technical review of the form to ensure that it has been filled out fully and completely, and a conflict of interest analysis to determine if there are conflicts. That third bullet, COI first, that's just kind of a loose OGE concept to best protect your filers. Essentially, what we recommend you do is treat the report as a request for advice. So essentially, the filer is coming to you and saying, hey, here are my holdings, these are my duties, am I going to be in trouble? Help me out. Unfortunately, especially for the annual reports, these all come in pretty much at the same time. What you may want to do is, for example, if you have a filer who you know the local newspaper always requests their copy for use in a funny news story, you might want to review and certify that one first. Or conversely, you might want to skim them all for any apparent obvious conflicts of interest, and then review both in technical and conflict of interest issues at the same time. We leave that up to you. It's just throwing something out there. If we have a potential conflict of interest, the agency has to remedy it. And we're going to talk a little bit more about that later, but that's kind of a big deal. Generally, the reports have to be reviewed and certified within 60 days, unless you are working on an issue with the filer. However, the reports are releasable to the public after 30 days, whether or not they are certified by the agency. And yes, I got burned by that once. So once again, that's why I kind of like using the COI first concept. Finally, they are maintained for 6 years at your agency and then destroyed unless being used for an active investigation. OGE also gets to certify certain reports from your agency, pretty much the presidential appointee requiring the advice and consent of the Senate and your agency DAO. And we have a similar process here. And if we have questions, we will go back to you. Okay, let's take a quick look at OGE's regulations. Once again, I recommend that you get a copy and actually read them. Not all parts will necessarily apply to your review, but it's still good to know. I recommend you spend a lot of time taking a look at subpart C in your regs, looking at the contents of the report, because that's going to be your main initial job as a reviewer. Okay, once again, the standards of conduct, OGE also promulgates these, and they apply to all federal government employees. And we are all expected to be familiar with them. And we were all given time to review them when we first started. And I doubt any of us remember that. It's a little beyond the scope of this class, but you should make sure you are aware at least of subpart E as impartiality. It's not a criminal concept, but it's more of a broadening of the concept of a conflict of interest. People can still get into trouble. Also, your review of the 278 may reveal potential standards of conduct violation, for example, in the area of gifts. Okay, next I want to direct your attention to part 2640. This is where OGE has given guidance on 18 U.S.C. 208. And the main problem with 208 is that it does not have a de minimis. Any impact on a financial holding, positive or negative, could be a crime. So OGE has developed regulations to interpret and give guidance on 208 and give exemptions for certain minor financial holdings. This could be very, very important for your conflict of interest analysis. And once again, we have a lot more guidance on this. As for Part C waivers, they are a potential remedy for a conflict of interest, but we don't need to worry about that yet. Okay, other review guidance. One of the main purposes of this training, in my view, is to make you aware of the guidance that is out there that can assist you in your review. Once again, you will not know everything about financial disclosure after this course, but hopefully you will know where to look. Listen, I can tell you my experience back in my agency when I was first assigned to review 450s, I didn't even know what they were. And then when I found out what they were, I was shocked and horrified and appalled that we would ask people about their personal financial holdings. But I got over it and then did my review, did a horrible job, really didn't know what I was doing. And the next year, I got assigned to do it again, and I'd forgotten all about it. But fortunately, I'd kept some notes. I knew where to go to. I could get my resources back. And hopefully I did a little bit better job that year. Most of the following resources can be found on the OGE website, including training modules and facts for training your filers, fillable forms, et cetera, et cetera. If you're not familiar with OGE's website, I strongly recommend that you add it to your list of favorites and explore it. One thing that OGE does is they promulgate ethics opinions on specific issues, including specific issues involving financial disclosure. They're really great places to go to if you hit something new and you're really not sure how to handle it. All you have to do is click on the OGE website, do a search, and the guidance will be there for a lot of the situations that come up. We also have a listserv and our MAX locations. That's how OGE promulgates information via email. I hope that you're signed up for both. That way you receive updates and other information. The forms themselves have a lot of guidance, okay? I recommend that you take the time to go through the forms. We're gonna do that today a little bit, but it's just, there's a lot of good information there. And if you're working with a filer on filling something out, if you can refer the filer to the particular instruction or the particular guidance, that could make your job a lot easier. There is a public financial disclosure, a reviewer's reference. That's essentially the guide. The old guide for the 278E was about 400 pages long. It just had a ton of good information in it. What I used to try to do back when I did training in this area before this was try to model the training just on the guide, because that way it made it a lot easier for the filers to refer to it. OGE has a new version of the guide, and as we indicated before, there's going to be a fundamentals course on that this coming Thursday. I strongly recommend you sign up for that because as I stated before, I'm going to sign up for it too. It's good review on both the review process and on financial instruments. Also, there's lots of financial information on the internet. Quite frankly, I don't know how people did this before there was the internet and they had to track down an unknown financial instrument. I recommend it highly. Once again, you need to know what your filer's duties are. If your agency has a local review, presumably you already know your filers. If they have a centralized review, you may need the filer's position description if you don't know their duties. We also recommend that you compare the report to any prior reports because it just makes your job easier. If the filer had a holding that was good last year and the filer's duties haven't changed, then boom, you're done with that holding. And it's what we do at OGE. It just saves a lot of time. An EA is an ethics agreement. If the filer has promised to do something, for example, sell a particular holding, you need to confirm continuous compliance with that, and that ethics agreement should be part of your file. Okay, this is just a slide on the old 278 guide because the new one is still so new that I actually haven't gone through it all the way yet. It's a really good demonstration or instruction on the process of financial disclosure. If you have it at your agency, and I hope that you do, please hang on to it. And once again, I recommend that you review it. And I'm such a big nerd that I actually have a copy at my house. So once again, I think it's good guidance. Okay, so getting to you, what is your job? Basically, when you get assigned a report at your agency, you have to review it. You compare it to a prior report, ethics agreement, agency info. You make sure that the filer has filled it out completely and correctly. And if you don't see any issues, that's great. Then you can either certify it or pass it up for certification. But if you do have issues or do have questions, you have to track them down. Initially, we can assume that the filer has been trained on how to fill out the report, has read the instructions, knows his own assets, et cetera, et cetera. But if you see obvious errors or omissions, or if you are independently aware of other issues, you are required to go back and get them resolved before you can forward the report. As a procedural matter, we really don't recommend that you return the report to the filer. The filer didn't want to fill this out in the first place, and definitely not going to want to talk to you about it now, so you may never see it again. What we recommend is that you get all the information that you need, get all your questions in order, and then get the filer's permission to amend the report at your level, and that just makes it easier all the way around. In addition, an entry may be sufficient for reporting purposes, but you may need to get additional information for potential conflict of interest issues. First off, just reporting a holding doesn't mean the filer is okay. Remember, we treat this as a request for advice. And also, a reporting example might be just a starting point for other potential conflict of interest analysis that are beyond the reporting requirements. So in other words, if you see something and it's reported correctly, but you still think it's going to be a potential conflict of interest, or you think there may be other potential issues, you still have to go back to the filer to get those resolved. You should annotate the form with any changes, and you should also maintain a record of your correspondence with the filer just to track your review. If you are in conversations with the filer about potential issues, that tolls your 60-day period. Essentially what's happened is that you've reviewed it, but you have questions, so you can't certify it yet, and that's okay. A big thing to remember, especially for the attorneys out there, is that you do not have an attorney-client relationship with the filer, which can be awkward. Your attorney-client relationship is with your agency, but you still have to go back and ask the filer certain intrusive questions. It can be awkward. Okay, let's start to look at the form. This year, OGES changed the format of the report to the 278E, but the content of the report is the same. It's just reported in a slightly different order, but essentially the content was mandated by Congress, so OGE can't really do much about that. Since we recommend that you compare the current report to the prior reports, you will need to be familiar with both. Yes, you guys are the magical lucky class that started doing 278 review right when OGE changed the form. But remember, those old forms for at least another 5 years are going to be the old 278 form. And if you have to go back and look at them, hopefully this will make that part of the review easier. I'm starting with the original 278 because it's easier to train from this form. And here are the contents. Essentially, the filer has to report certain assets and income, certain transactions, report certain gifts and gifts of travel, report certain liabilities, report agreements and arrangements for outside employment, report any currently held outside positions, and for new entrants, they have to report compensation above $5,000. Basically, Congress had determined back in 1978 that all of the covered employees have to report their private information in these areas. At the time, Congress balanced the filer's right to privacy with the public's right to know under the statute to come up with these uniform reporting requirements. Now, this also includes the reporting of certain spousal and dependent child holdings. And believe me when I tell you that this was litigated to the Supreme Court back in the day. The Supreme Court denied certification, let the appellate court holding stand, and the appellate court had said that, yeah, actually Congress did a pretty good job balancing these two interests. So this is what we have, and this is what we have to deal with. However, there are very specific requirements and exceptions for each holding or reporting, and we will go over those later. That's what the 278 looks like. This is what the 278E components look like. So as you can see, the reporting requirements are the same, but the order has been changed. Apparently, OGE wanted to focus on the holdings of new covered employees when they are coming onto federal government service. And we're going to talk through that in a couple minutes. Okay, this is a handout that you have. If you're going back and forth between the reports and you're new to this, it's easy to get a little bit confused. So OGE came up with this chart. It essentially tells you, if you're looking at Schedule A, it compares over to parts 2, 5, and 6 on the 278E, et cetera, et cetera. I still use this for my review this year as a tool for my review comparisons. I'm sure that next year we'll all be beyond this, but this is just something that you may find of use when you do your reviews. Next, I wanted to talk about the instructions on the 278. There is a lot of good guidance there, and I recommend that you review it. But I did not include it in your materials. I assume you have a copy in your offices. Essentially, it's 11 pages of fine print. I doubt that any filer ever read it, but I recommend that you read it just so you know where the information is. I'm only going to quickly show you the first 3 pages. On the first page, we have the reporting periods. We're going to talk a little bit more about that later. It also has information on scope of disclosure and definitions. On the lower right-hand corner in particular, it says accepted investment fund. And we're going to talk more about that later. But if you ever get a question on it in the old form, this is where that information is. On the next page, it gives guidance on who has to file. Presumably, your agency has already determined that. And page 3 talks about a little bit more about the specifics of when to file certain extensions that can be granted and the late filing fee. Basically, OGE has given the agencies authority to grant extensions if a filer is having some issues and can't file the report on time. However, if the filer ultimately files the report more than 30 days late, the filer is required to pay a $200 fine. And I guess back in 1978, $200 was a bigger deal than it is today. But it's a punishment that can hopefully ensure timely filing. The late fee can be waived in certain circumstances. And once again, OGE has pushed that down to the agency level, but has given guidance. And I have to tell you, one of my run-ins with that was a DAO at an agency, and the agency was actually going through a physical relocation where they were moving the agency from one building to another, and he forgot to file his 278 during that time. And so I said to him, look, that's kind of an extraordinary circumstances. Maybe you could cut yourself some slack on that one. And to his credit, he said, no, I'm the DAO. I'm the designated agency ethics official. I'm supposed to be on top of this. So he actually made himself write out a $200 check and pay the fine that way. So it is out there. Okay, the 278E instructions, these are included in the handout. These instructions are good, but they don't have as much detail as in the 278, but still are of assistance to the filer, and you as a reviewer should be familiar with them. Okay, a little bit more into the weeds on filing deadlines. There are due dates depending on the filer's status. Essentially, if somebody's coming in new to the job, they have to file it within 30 days of assuming the job. Every year, annual filers have to file by May 15th. And once again, that depends on the working, the calendar. I believe this year it's May 18th because of a holiday. For termination filers, they have to file it within 30 days after leaving the position. The 278 is designed to cover the entire federal government duty arc of a filer. So it has to start pretty much when they begin, cover every subsequent year, and then cover the date that they depart. Once again, there can be extensions. That's at the agency discretion, and there are some limits. When it comes to the filing periods that are covered by each report, I've included as a handout the Army handout, and I call it the Army handout because the Army came up with it and I just stole it. So, for example, new entrants, depending on the part, either have to go back a year or go back longer than a year for reporting purposes. And once again, hopefully your agency can help you with that. And also, if you take a look at the handout, it's got a lot of good guidance right there. All right. What I'd like to do now is take a quick 5-minute break. I've got 11:45. Why don't we come back? Well, actually, I have 11:46. Why don't we come back in 5 minutes, and then we'll start off again looking at the 278. Okay, thank you very much. So please feel free to take a break and hit the head and check your email or whatever you need to do. I'll be back in 5.
You will now be placed into conference.
Okay, it's Mark and I'm back again. Sorry, it took me a little bit longer than I had anticipated. But what I'm going to do is go through the form. Oh, actually, excuse me for just a second. Okay, once again, this is Mark and I'm back and I apologize for the extra delay. Well, what I'd like to do is just walk through the cover sheet of the 278 very, very quickly. And once again, I did not include this with your materials, but presumably you're going to be seeing it when you do your review. Essentially, what we're looking at here is the filer's personal information or contact information or official duty information. And what I'd like to point out is that actually the cover sheet does have other guidance for the filer, including the right-hand column where it talks about the late fee and it talks about reporting periods. Going down past the filer's name, position, etc., this is where the agency would certify the report right in the middle. And below that, if an agency had intermediate review, for example, if the agency wanted the filer's boss to look at the form before sending it over to legal to get certified and wanted to track that, that's where the agency would handle that information. Right below that is the Office of Government Ethics Use Only. Once again, we certify PAS types and DAOs, and that's where we would sign that form. Below that, if the agency had any issues or had to make any corrections or amendments, it's always a good idea to let the subsequent people who look at the form be aware of that. And so that's where that information should be collected. Now let's compare that to the 278E cover sheet. It doesn't have quite as much detail requested, especially concerning the filer's contact information. But essentially on the top left, you can see where the the filer would fill out the report type and the date of appointment. For your handout, there's some data there, but once again, that's going to be used for the exercise, so you can either make use of it now or just ignore it for now. In this case, our filer is James Nicklick. He's the Assistant Secretary for Procurement at our made-up agency. The signature and date requirements are the same as the 278, and also there's a section for making comments. Okay, once again, my training is going to be based on the original 278E. So we're going to start out with Schedule A, which is assets and income. And that's going to be our process for the rest of this lecture. We're essentially just going to discuss the reporting requirements and then look at the actual 278 and 278E forms. Remember, some spouse and dependent child interests are imputed to the filer, so they have to be reported too. Filers must report assets with a fair market value of over $1,000 at the end of the period, or that accrue more than $200 in investment income during the period. Assets are things held for investment or the production of income. For example, stocks, bonds, mutual funds, rental property, and there are examples on the 278 form. Reporting is based on whether the asset exceeds the threshold amounts. In other words, whether it's worth over $1,000 at the end of the period or earned $200 during the period. Income is money coming into the filer, either from the assets or from services. Investment income or unearned income is typically interest, dividends, capital gains, that sort of thing. Earned income or non-investment income is typically salary, wages, fees, honoraria, and honoraria is kind of a big deal. That's payment for an appearance, speech, or article. And in that scenario, the filer's exact amount of income has to be reported. Generally, spousal income has a higher threshold to be less intrusive, except for honoraria, because apparently Congress determined that spousal honoraria was a bigger potential for a conflict of interest. So the cutoff is the same, but for the spouse, the exact amount is not reported. And there are other non-reportable assets and income. Filers don't have to report a personal residence. However, we're going to talk later about the Stock Act. So now there is a new exception for that particular asset. Government salary and other benefits, including our TSP, are not reportable. And anything resulting from the dissolution of a marriage, including alimony or child support, are not reportable. That's a little bit too intrusive, and there's obviously a much lower potential for a conflict of interest in a situation like that, or at least a conflict of interest that the federal government is concerned about. Don't report any dependent child earned income. Once again, that's what's determined to be too intrusive and not a real potential for a conflict of interest. Okay, let's talk about examples of assets. This is not exclusive. New ones develop all the time, and you need to be able to understand them for conflict of interest purposes. If you're like me, I don't have much of a financial background. Through my entire Coast Guard career, I was mostly concerned with a savings account, a checking account, student loans, and child support payments, and that was the limit of my financial experience. But if you see a holding that you don't recognize, you have to look it up. You can use OGE guidance or the web to track down more complex financial instruments. And once again, my favorite one here is on the lower left side of livestock. I actually had a filer who loved to play the ponies and also owned racehorses. And apparently you can buy and sell portions of potential foals. And I had no idea that you could do that, but hey, it was an asset. It had to be reported, and I had to track down what it was. A little bit more about the finance side. And once again, this is just basic financial information you need to have, or at least need to be aware of for reporting purposes. These are examples of investment vehicles whose underlying assets need to be broken out, if otherwise reportable. These are referred to as portfolio holdings sometimes. So for these holding entities, the potential conflict is with the underlying contents, not the holding entity itself. If you see this type of entry and no underlying assets, you need to get more information. And I got to tell you, this was a mistake that I made back when I was first doing financial disclosures, that if I thought that somebody had an IRA or a 401k, then I thought it was okay. And for example, something like a TIA-CREF, that used to be okay, but TIA-CREF started getting creative, and OGE actually had to come out with guidance on what underlying TIA-CREF holdings have to be broken out these days. As for 529 plans, their education savings accounts, they're something that we see more and more these days. Essentially, this is how people can save for their children's college education and get a tax break. There are two basic types. What I'm just going to tell you now is that if you see one and you don't understand it, OGE has come out with particular guidance on this in an advisory opinion. And if you do have that happen, I recommend you get a copy of that opinion and look it up. Variable annuities, that's just another typical example. If you don't know what it is, you got to look it up, and you have to make sure that the filer is breaking out the reportable underlying assets. Typically, a filer will just report the investment vehicle and then list the reportable underlying holdings underneath it on the form for convenience. However, there is an exception to this. Remember when I talked about the accepted investment fund before? That's an investment vehicle that is widely held, publicly traded, or widely diversified and independently managed. And if there is an investment vehicle that meets all those three requirements, then the filer does not have to list out the underlying holdings on the report. And this can be a big deal because a lot of holdings can have like literally thousands of underlying holdings, and it's just a nightmare to try to break them all out. However, this is just a reporting concept that Congress came up with when they developed the 278. If a holding is still a potential conflict of interest, you as a reviewer may need to do some more homework to try to track that down. A mutual fund is, as you can see, an entity that is registered as a management company under the 1940 Act. Mutual funds are automatically EIFs, and they are a very common entry. OGE has determined that diversified mutual funds are not a conflict of interest, but a sector mutual fund may be. And a sector mutual fund is one that deliberately concentrates the underlying holdings in a particular business, sector, industry, country, et cetera, et cetera. Once again, it's a little bit beyond our scope here, but it's something that you need to be aware of as a reviewer. And we have, or excuse me, OGE has a lot of guidance both on EIFs, mutual funds, sector funds, et cetera, et cetera. But the bottom line is that for reporting purposes, the filer does not need to break out the underlying holdings. Okay, now let's talk about the retirement plans of people who worked in the private sector before becoming onto federal service, because they could be an investment vehicle and they could be a potential conflict of interest. Basically, the defined benefit plan is the more traditional type of retirement plan. For example, an employee works for the XYZ company for 30 years. The company guarantees a payment of $1,000 a month starting at age 65. The filer has no knowledge of any particular underlying assets, mostly because there aren't any, and he just knows that the company will pay him that amount at that age. The filer has to report the plan because it is an asset, but of course, no underlying assets are reported. Now, a more common entry these days is a defined contribution plan. That's where both the employee and the company pay into a fund. The employee selects the underlying holdings. Hopefully, the amounts will grow in value, and that becomes the employee's retirement income. The employee has knowledge and control, so therefore has to break out those underlying holdings, because since the filer has control, it is not an EIF. Typically, this is a 401k or a 403b, and in fact, anything similar to our thrift savings plan, but of course, our thrift savings plan is not reportable. Okay, let's take a look at the form for Schedule A. Starting from the left where it says assets and income, going down to block A, that's where the filer would type in or fill in a form, or had filled in the form, for the information that was required to be reported, and right underneath that gives the same instructions that we just went over. Right below that are examples, and we're going to go over them in just a second. To the right of that is the valuation of the assets. These are not net worth statements. We don't need exact amounts. We just have valuation ranges that the filer is supposed to fill out. To the right of that column, that's where the filer would check if an asset was an accepted investment fund. And just to the right of that, it talks about trusts. Don't worry about trusts right now. That used to be a big recruiting tool, but it actually didn't work out that well. And I'm pretty certain that there aren't any accepted trusts or qualified trusts in the federal government right now. To the right of that is where the filer checks the income. First, the filer has to check the type of income, and then to the right of that, the amount of income in a range. If the filer has to give a specific amount, then that information is to the right of that. And if the filer was involved with honoraria, then the filer also has to report the date. So let's look at our first example right below that, where it says Central Airlines Common. The filer has checked a valuation of the asset of $50,000 to $100,000. Further to the right, the filer has checked a dividend amount and an amount of $1,000 to $2,500. We can assume that that's a stock because it paid dividends. If we're not sure, then what we would do is just jump online. However, the best thing to do is just go back and check the prior report and see if that entry is there. If it is, then we're good. If our filer can't take any official action that could impact Central Airlines stock, then boom, we're done with that entry. The next example is Dow Jones and Smith, hometown state. The filer has checked a valuation of an asset, and then all the way to the right has indicated that there's law partnership income of $130,000. This entry is typical of an attorney coming from the private sector into the federal government. Obviously, that's the law firm, Dow Jones Smith, and also it indicates that the filer is a partner, so it has an equity interest in the firm, which is an asset, and gets a salary from the firm. So that's why that entry has both assets, or both amounts checked. We're also going to presume that we're seeing this on a new entrant for the first and only time, because next year our filer will have been in federal service for a year and will have severed all ties with the law firm. And of course, we will double check that as ethics officials. The next entry is Kempstone Equity Fund. The filer has checked the valuation of the asset, has checked the EIF block, and has checked an amount of income. Since it looks like that's a mutual fund, the filer doesn't have to check the type of income, just the amount, because the filer may not know the exact type of income of the underlying holdings of the mutual fund. Okay, so that's a good entry as well. Below that, the filer has an IRA, which indicates it only has one holding, which is the Heartland 500 Index Fund, and the filer has reported it the same way as the entry above it. The only thing we might want to check here is to make sure that there is only one reportable asset in the IRA. Okay, those other entries are for our exercise tomorrow. For the 278E, this information is recorded in Part 2 for the filer only. Okay, so we're presuming that the filer is coming to federal government service, coming from a prior job with income and assets. This is where the filer reports that. And as you can see, the reporting requirements are pretty much exactly the same as on the 278. The only difference is in the format. Instead of having all the columns, the 278E has drop-down menus and things like that. And as I guess I just spoke before, please just ignore the data entry for now unless you want to start working on the exercise earlier. For the 278E, at Part 5, the filer also reports any spouses, employment, assets, or income. Once again, the 278 has divided this out between the filer and the spouse to focus more interest and attention on new entrant filers who may have spouses who also have employment, interests, or income. Finally, on the 278E, at Part 6, the filer reports any other assets and income that are not directly related to the filer's or the spouse's employment interests. Okay, so where Schedule A of the 278 had everybody's assets and income reported in one place, the new 278E breaks it out into 3 different reports or parts. Okay, great. Now, what do we do? What we're going to do now is essentially do this the same for all the parts that we look at. We're going to do the basic requirements for a technical review. In other words, we just need to ensure that the report was filled out completely and correctly. For annual reports or termination reports, once again, it's best to reconcile these reports using the prior year's report. And for our technical review, we're looking for any unexplained inconsistencies in the reporting from the prior year's report. Also, for ethics agreements, if the filer agreed to divest of an asset, you need to make sure that the filer doesn't subsequently reacquire it. So you need to check the ethics agreement as well. For our conflicts of interest analysis, we're just going to be looking at the basic issues that you should be familiar with, but are, of course, beyond the scope of our training. When conducting a conflict analysis, there's a wide variety of potential conflicts. If the filer can take an official action that affects a personal interest, then we have a 208 issue. If there are any appearance issues in personal or business relationships from the standards of conduct, you may need to look into those too and get more information. Remember those representational issues like my Coast Guard junior officer who wanted to report back representing an outside entity? Obviously, that would have been a problem. And if we have any supplementation of salary issues like our Bureau of Mines employee who wants to get that $380,000, then we're going to look into that too. Okay, now we're going to look at Schedule B of the 278, and that has two parts. This is where the filer used to report transactions and gifts and reimbursements and travel expenses. Let's look at transactions first. The filer has to report a purchase, sale, or exchange of stocks, bonds, mutual funds, and other securities and real property of a value of over $1,000. This does apply to the filer, the spouse, and the dependent child, but this is not for new entrants and nominees. For new entrants and nominees, it's considered too intrusive and too much of a record-keeping burden for the filer to need to know what they did a year ago for reporting purposes as a new entrant. So this only applies to annual and termination filers. Now, the Stock Act requires some additional reporting throughout the year for some people, for some assets, and we're going to talk more about that later. But the basic transaction requirement for things that are not reportable, we don't care about the purchase or sale of a personal residence. We don't care about transactions on cash accounts. And once again, we don't care about most federal interests because for one thing, it's too intrusive. And for another thing, there's a much less potential for a conflict of interest. This is part of Congress's balancing act. So this is how it's reported. Excuse me, on Schedule B, Part 1. And just take a quick look at this here. The information on the left-hand side is all the information that we just went over. The first column is the identification of the asset. And in this example, the filer reported Central Airlines Common. We take to the right of that, and we see that the transaction type was a purchase. To the right of that, the filer gave us a date, which is obviously out of date. And then to the right of that, the filer reported the amount of the transaction. Now, if this was a purchase during the reporting period or even prior to the reporting period, we would expect to see that on Schedule A. And in our example, we did see Central Airlines common stock. On the 278E, this information is reported on Part 7. And as you can see, the requirements are the same. It's just in a different part of the form. So for our technical review, basically, once again, did the filer give sufficient information? Did he fill out the form fully and completely? Did he give the date, type, and amount for each asset? And as indicated on the 278, for the 278E, if the filer did purchase something new, I presume it would show up on either parts 2, 5, and 6, probably part 6 as a new purchase. For our conflicts, once again, our basic conflicts, did the filer purchase anything that he or she should not have purchased? Anything that was prohibited by an agency's statute, regulation, or other requirement? Is the filer purchasing anything that he may also have an impact in concerning agency contractors? Prohibited sources, this is a gifts concept from the standards of conduct. A prohibited source is essentially an entity that does business with our agency, wants to do business with our agency, is regulated by our agency. Anything that a federal, an official action at our agency could have an impact on that outside entity. Did the filer sell any assets as directed by the agency? Usually this is in connection with an ethics agreement. And once again, we need to make sure that the filer is continuously in compliant and did not subsequently repurchase that asset. And yes, I have seen that happen. I used to be the desk officer for State Department. A lot of the political appointees to be ambassadors are very, very wealthy people who have their own financial people handling their holdings. Somebody who's going to be a new ambassador may agree to divest of a particular holding and will subsequently divest of that holding. But in subsequent years, that filer may change financial people or something else may happen, and that filer's financial people may subsequently repurchase that asset, either to round out a portfolio or sees it as a good investment. A lot of times the filer signs the report, but may not be aware that if we see that in our review, that's kind of a big deal. And we have to go back to the agency and the filer to confirm that the filer didn't take any official action that could have impacted that holding. Okay, now this is sort of a segue about the 278T and the Stock Act. In 2012, Congress enacted the Stock Act. Basically, the statute made it against the law for a member of Congress to use inside information in any financial transactions to their personal benefit. Remember before when I said that usually there's some sort of scandal and Congress makes it against the law? Well, essentially that's what happened, because for all of us regular federal government employees, it was already illegal for us to use inside information. But Congress made their subsequent changes to the reporting requirements applicable to executive branch personnel as well, I guess just to show how tough and strong and resolute they were. As you may recall, this resulted in many lawsuits and headlines, etc. And during this time, OGE promulgated several advisory opinions to give agencies guidance. Mostly we did this because we were not consulted when this was going on. We sort of found out about it afterwards, and so we had to really do some scrambling. We also promulgated the 278T financial disclosure form for reporting transactions that occur during the reporting period. And I'll talk a little bit more about that in just a second. So these are the legal advisories that OGE promulgated. If you're going to be resuming 278Ts, and I presume that you are, you might want to make yourself familiar with these as well. Certain senior filers have to give advance notice on job searches. Certain senior filers now have to list their home mortgage, not just any rental properties. So that's a new one. For the next two advisories, OGE promulgated the 278T, and subsequently spouse and dependent child transactions also have to be reported. What happened here was that Schedule B and Part T, the transactions were only reported at the end of the reporting period. And that's the way it was with the 278. That's the way it was for all entries. Essentially, the filer reports on May 15th, and the report covers the prior calendar year. So we're already potentially a year and 5.5 months before the reviewer can take a look and see if there are any potential problems. That's kind of some kind of stale information. And if somebody got into trouble a year ago, yeah, we're not going to be able to remedy that one very easy. So Congress said that for transactions, the filer has to do it within a certain time frame instead of waiting to the end of the reporting period. And we'll talk a little bit more about that in just a second. Because of the confusion about when this came out, OGE have given a waiver of the late filing fee, because the late filing fee applies to the 278T as well as the 278 and the 278E. But now filers and agencies are expected to be on top of this. And if a filer submits a 278T more than 30 days beyond the due date, then the $200 fine will apply. Okay, I'm not going to go into detail on the 278T, but this is what the form looks like. You can get it off OGE's website, and it gives the reporting requirements, which are pretty much the same as the regular Schedule B and Part T. One thing to note is that the 278T does not apply to all of the reportable instruments on Schedule B and Part 7. For the 278T, the filer only has to report securities and does not necessarily have to report EIFs. However, this is kind of a confusing factor because the filer would still have to report EIFs on Schedule B and Part 7 of the next year's report. OGE recommends that the filer report everything, essentially over-report on the 278Ts. And that way, at the end of the year, the filer can just leave it blank because everything was reported on the 278Ts. Now, we leave that up to the agency discretion. And once again, agencies have been doing this for a while now. So by all means, when you get back to your office, just do what your agency requires. The difference in the 278T is when to file. A filer has to report a 278T within 30 days of receiving notification of a transaction, but no later than 45 days after the transaction. The presumption there is that the filer's got to get a monthly brokerage statement. We'll see that he made some new purchases and will then go fill out the 278T. This is what the 278 actually looks like. Basically, the reporting requirements are the same. We need the filer to sign it and fill out the other personal information. We need the filer's date so that we can confirm the actual purchase, sale, or exchange, whether or not it was reported timely. If we see the examples, the first example is, once again, Central Airlines Company. We have the filer's transaction date, month, day, and year. We see that it is a purchase and we have an amount. We would take the transaction date and compare that to the filer's submission date to make sure it was timely. The example below that is BMSL Propulsions Incorporated. If we didn't know what that was, we would have to look it up. But once again, we see a date and we see that notification received more than 30 days ago. This is how the filer lets us know that. Once again, we see it's a purchase and we have an amount, and we would do our measurement based on the submission date, but we would have 15 extra days of grace for the filer. Okay. That's about it for the 278T and how it impacts us for transactions. Okay, so for our agency technical review and conflict of interest review for the 278T, did the filer fill it out timely? Did the filer fill it out completely? For our ethics agreement or conflict of interest, if the filer purchased something that he shouldn't have, we need to note that. Does your agency require additional reporting on the annual report? If so, you will know that. And once again, for your PAS types and your DEOs, those reports are also forwarded to OGE for our review. And yes, we do look at them. Okay, let's take a look at part 2 of the 278, gifts and reimbursements. Filers have to report gifts and travel reimbursements that exceed $375 from any one source, whether or not they're received by the employee, the spouse, or the dependent children. Every 3 years, that gift cutoff amount gets changed. Our most recent guidance was in 2014 at LA-14-03. So in 2017, we'll be promulgating new guidance. Basically, a gift is anything of value, and a travel reimbursement is money given to the filer to cover travel costs. Of course, there are exceptions to this. The term relatives is defined in the instructions very broadly. For the filer, we have guidance for them to estimate value of the gift paid, basically fair market value. Anything that's accepted by the federal government is not a gift to the employee. For example, 1353 travel gifts are gifts to the government, but a gift of attendance at a widely attended gathering would be a gift to the filer. And I know I'm throwing a lot of terms out there at you, but OGE has a lot of guidance on this. Anything given to the spouse or dependent child that's totally independent of their relationship to the filer. And essentially what we're saying there, if somebody is giving a child a gift in a means to bribe the filer, then that gets reported. Bequests and other forms of inheritance are not technically gifts for our reporting purposes. However, if grandma passes away and leaves the filer IBM stock of over $1,000, that would still be reportable on Part 6 because it is an asset that the filer now owns. And a lot of times when that happens, you'll see that the filer will just make a little note on the 278. That way, it explains why there's no transaction. Okay, let's take a look at Schedule B. And you see in the instructions the information that we just went over. The first column to the left, we need a name and address for the source of the gift. And to the right of that, we need a brief description of the gift. And then to the right of that, we need the value of the gift. The first example was a National Association of Rock Collectors. And we have a travel itinerary and date. And the filer helpfully put in personal activity unrelated to duty, and then the amount. And for our reporting purposes, we're done with that. For our conflict of interest, we're probably done with that one too. The next entry was the source, Frank Jones from San Francisco, a brief description of both the gift. And once again, our filer helpfully included that it's from a personal friend with the value of $300. For our 278E, that same information goes in Part 9. And once again, the reporting requirements are the same. The format is just a little different. Okay, for our technical review, did the filer fill it out fully and completely? Travel requires an itinerary and a date. It can be a brief itinerary. And for our public purposes, must the filer report each item disclosed? If the filer over-reported a gift and we think that the filer's report might be requested for release by the public, we may want to go back to the filer and say, you didn't have to report that, maybe we can just redact it. Once again, that's something that you handle at your agency level. But I can tell you this, that every year the Washington Post requests a copy of the president's and vice president's 278 forms and writes an article discussing all the gifts that they received. So just saying, it might be something that you may be concerned about at your agency. Okay, for our conflict of interest analysis, once again, as a reminder, the reporting requirements for gifts are fairly broad. The conflict of interest analysis may or may not come into play. If somebody is trying to bribe a public official by giving them a gift, probably not going to report it, but it's something we need to be aware of. The next bullet actually talks about standards of conduct issues. It's a little bit different because the filer has to report gifts, whether pretty much individual of the source. So what we look at here is whether the source was a prohibited source or if the gift was given because of the filer's official position. And this is where we do our standard of conduct gift analysis. And if we do find potentials, then there are remedies also in the standards of conduct regulations. Okay, let's talk Schedule C, liabilities and agreements or arrangements. Once again, Schedule C consists of 2 parts, and we're going to go through them one at a time. For Part 1, the filer reports liabilities. Essentially, liabilities are just debt, money that the filer owes to another. The purpose of reviewing liabilities is to ensure that they do not indicate the receipt of gifts or any special favors under the guise of a loan. The filer has to report any liabilities exceeding $10,000 during the reporting period, as opposed to at the end of the reporting period. Once again, just to make this a little bit less intrusive, this does apply to the filer, the spouse, and dependent children. Remember the Stock Act, PAS filers now have to report their home mortgages as well. And also there are non-reportable liabilities. There are exceptions. Anything within the family, anything that's secured by a vehicle, furniture, like a car loan, things like that, and any revolving charge card under $10,000 at the end of the reporting period. And by revolving charge accounts, we're referring to credit card accounts. For credit cards, they're treated a little bit differently because there's less of a potential, and it's kind of intrusive to know if somebody's running up too much credit card debt. Okay, so let's take a look at Schedule C. Once again, on the top left, the instructions cover pretty much what we discussed. On the left column, we need the creditor's name and address. To the right of that, we need the type of liability. Then for our reporting purposes, to the right of that, we need the date incurred, the interest rate, and the term, if applicable. And then to the right of that, we need the category or amount. For our first example, we have the First District Bank, Washington, D.C., and the filer is reporting a mortgage on rental property from 1991, 25-year mortgage, 8%, and then we have the value of the mortgage. Technically, that entry is sufficient, and for conflicts, people have rental property. The only potential conflict would be if they were renting it out to a prohibited source or something like that. The next entry is John Jones, Washington, D.C. It's a promissory note due on demand. If that's new, we may want to go back to the filer and say, who is John Jones? If it's something, a personal friend or something like that, then we're okay with it. If it turns out that John Jones is a prohibited source or a contractor, then we might want to do a little bit more digging. For the 278E, that information is located at Part 8. And once again, the required information to be reported is the same. So real quick for our technical review, did the filer fill out the form completely? If it contains a liability such as a mortgage on rental property, that should also be reported elsewhere on the form. And that should say Part 6 instead of Schedule A. Sorry about that. And you should track liabilities year to year the same way we do all the other assets, holdings, positions, transactions, et cetera, et cetera. For our conflicts, are there liabilities with prohibited sources like I indicated? Are there liabilities with other employees? Because these would both be standards of conduct issues. And generally, are the terms available to the public? If our filer is getting a sweetheart deal because of the filer's official position, then we have another standards of conduct issue. Okay, next, for part 2, this is where the filer reports any agreements or arrangements. And what we're concerned here is just the filer. What we're looking for are agreements concerning future employment, any current employment, if, for example, the filer is on a leave of absence, or former employment if there are any continuing connections with the former employer. The leave of absence, that's not uncommon for university professors. They're tenured at their school or college, and they want to come and work for the federal government, knowing that they're only going to work for the federal government for a certain period of years and then go back to the college or university. As long as everybody knows that and everybody's been advised on that, that's not going to be an issue, but it's still reportable. Okay, let's take a look at Schedule C, Part 2. Once again, the information, required information is in the descriptions, the definitions, excuse me. The first column, we just need the status and terms of any agreement or arrangement. To the right of that, we need the names of the parties, and to the right of that, we need the date. In our example, we say pursuant to partnership agreement, we'll receive lump sum payment of capital account and partnership share calculated on the return of service, blah, blah, blah. The party is the prior law firm, and the date would be the date that the filer entered into that agreement with the law firm. That's fairly typical and fairly common, and technically it's a good entry, so we're pretty comfortable with that. For the 278E, this information is located in Part 3. Once again, it's more towards the beginning of the form because OGE is more concerned about getting prior employment information resolved earlier in the form. Once again, for our technical review, what type of agreement is in place? What are the terms of the agreement? What's the current status of the agreement? Do we have the name and the date? Are there any assets and incomes related to it? If so, if they're reportable, would they be on Parts 2 for the filer or Part 5 for the spouse? For our for our conflicts, if the filer got a sweetheart deal leaving the agency to come into federal government service, we need to look into that. And we need to be concerned about the filer's official duties and any parties to any agreement or arrangement. And there also could be an appearance issue under the standards of conduct with former employers. Now, if our filer is looking to leave federal government service, for certain senior filers, they need to notify us of this under the Stock Act. And we should be aware of this because if a filer is negotiating and has agreed for future employment, whether or not all the terms have been finalized, the filer has a full 208 agreement with that new employer. If the filer is just seeking employment, then we have potential 502 issues. Hopefully our filer is comfortable enough to come and talk to us when they're looking to leave the federal government. And also certain senior filers automatically get counseled when they're getting ready to leave the federal government. My only experience with that was when admirals would retire from the Coast Guard, it was at least 2 attorneys and at least a half a day counseling them on what what they can and cannot do once they leave the federal government. For less senior people, for example, if a contracting officer wanted to go work for a contractor. In the Coast Guard, we called it a safe harbor letter. And what would happen is the contractor would know more about this than the filer. And when the filer said, yeah, I'll take a job with you, the contractor would say, go back and get a safe harbor letter from the legal office. And so the person getting ready to leave would come sauntering into my office and say, hey, I need one of those safe harbor letters because this is my last week and I want to start work next week, getting that big private entity paycheck. And they didn't have a very pleasant look on their face when I handed them a multiple page form that they had to fill out so that I would know the information to give advice to them. Yeah, I received several unkind words about my character when I was going through that process, but I'm over it. Okay, let's go on to Schedule D. Schedule D refers to any positions that the filer holds outside of the U.S. government. And also Part 2 is for new entrant filers, and we'll talk about that very briefly. So for outside positions, these are just examples. They're not exclusive or inclusive. What we're looking for here are positions with a financial interest or fiduciary responsibility in outside entities. We don't care if they're paid or unpaid, profit or not-for-profit. We just want to know what the outside entity is, and we want to know the filer's position there. And there are exceptions. The filer does not report positions held by the spouse or dependent children. This is only for the filer. Once again, it's a little bit too intrusive for the spouse and dependent children. Is there a potential for a conflict? Maybe, but it's not reportable. Anything they hold in an official capacity, and by that we mean their official government capacity as part of their job. Typically that is in a representational or ex officio as part of their federal government duties, and they are not a fiduciary. Back in the day, the DOJ came out with an opinion, God, years ago on this, saying that it's inappropriate for federal government employees to have positions with fiduciary responsibility in outside entities because it's kind of like trying to serve two masters. And it was quite a big deal, once again, especially in the Coast Guard, because every captain of the port or local commanding officer was automatically made a member of the board of all the yacht clubs in that particular area. And it wasn't a really big conflict of interest. It was mostly just a chance to get for free dinner and open bar. But since there were members of the board with fiduciary responsibilities, we had to go in and redo all those board memberships to make them just ex officio and not let them have any responsibilities. So it was kind of a pain. Also considered to be too intrusive are religious, social, fraternal, or political organizations. If you see a situation like that, OGE does not have a lot of guidance on this. You're probably going to have to go to the filer or go to the outside entity, get their charter, and do some digging. Anything of an honorary nature, like Professor Emeritus, that's not going to be a problem because there is no fiduciary responsibility, and mere membership of an organization is fine. I'm a member of the Florida Bar, but I'm not the president of the Florida Bar. So just my bar membership would never be a potential conflict of interest for me. Okay, let's take a look at Schedule D. Once again, the information is on the top left of the form. The first column, we need the name and address of an organization. Next column, the type of organization. Next column, the position held. And then after that, the dates it was held. For our first example, our filer is a member of the National Association of Rock Collectors. It's a nonprofit education organization, and he's the president, has been since 1992. That's technically correct information, And if we think our filer's rock collection would be a conflict, we would counsel him on that. Next is the filer's prior law firm for the new entrant. It's duplicate reporting because the filer already let us know this on Part 2 and also Schedule A in this case, but that's okay. The report does allow for duplicate reporting because it was still an outside position held by the filer. For the 278E, this is the first part that the filer would fill out, presuming that the filer had an outside position and is coming in from the outside. Once again, the required information is the same. For our technical review, once again, is all the information reported? Did the filer report more information? If the filer is reporting things that don't have to be reported, once again, we might want to clean up the report for the filer's sake. If the filer is a current employer of the federal government and wants to get an outside position, many agencies have a prior approval requirement, and usually that's done in the same legal office that does the financial disclosure. So you would know if the filer had obtained prior approval, and if you didn't know about it, you should probably look into it. Finally, if the filer was in a paid outside position, that would also be reported on Part 2 if it was income of over $200. For our conflicts, essentially, does the outside organization have any particular matters or interests with our agency? And if so, do the filer's official duties impact the outside organization? And particularly along these lines, what does our filer do with the outside organization? And once again, remember my Coast Guard junior officer, for 203 and 205 issues, a federal employee can't represent an outside entity back before the federal government. Okay. Moving along for Schedule D, Part 2, compensation in excess of $5,000. This is for new entrants. And typically what we're looking for here is to collect information on clients, for attorneys, lobbyists, et cetera, for potential conflict of interest with those parties. It has an extended time frame, and since it is for new entrants. And it also would include any salary that the filer was paid by his prior, for example, law firm. And what does the filer not report? If there was a pre-existing confidentiality agreement, that's fine. If there's a court seal on a legal matter or an ongoing investigation, that's fine. Anything to do with the federal government, that's fine. And if you're dealing with a new entrant or a new PAS, check out this advisory opinion because it gives a lot more information in this area. So for Schedule D, Part 2, we have the instructions. And as it says there in big bold letters, do not complete this if you're an incumbent, termination filer, or presidential candidate, et cetera, et cetera. It's only for new people coming in. We need the name of the source and a brief description of the duties. For our examples, the first entry, the filer reports his law firm and his duties for legal services that he got paid for. And once again, we're seeing this for the third time on a new entrant form, but that redundancy reporting was taken into account when Congress came up with this form, and they said, fine, tough, just deal with it. Now, the second example is Metro University, which is a client of the law firm. And the description is that our new entrant provided legal services in connection with the university construction matter. That's all the information we need. And once again, this is fairly early in the 278 E form. This is entered into at Part 4. What's our technical review? Did filer fill it out fully and completely? And is more information disclosed and required? If so, then we may want to take that out. For our conflicts of interest analysis, I'm not going to go into that much detail here. This is a first-time thing. It can be a very big deal. If your agency is dealing with these types of issues, I'm presuming it's going to be done at the more senior level, and we'll let those people handle it. Once again, I just want to make sure that you are aware of it. Okay, I know I ran a little bit late for our second hour, but quite frankly, I think we're pretty much done with the first day's session. So what I'd like to do is just take a couple of minutes and go through what we're anticipating for tomorrow. First off, wow, that was really, really boring and really, really long. Please don't hate me. But before we meet again tomorrow, please take the time to go through the data on the 278 in the materials. It's a fake filer from a fake agency, but pretend that you are a new ethics official at that fake agency and you have been tasked with reviewing the report. Please do what we did here today. Examine it for technical sufficiency and potential conflicts of interest. If you think of any questions that you would have for the filer for either technical issues or conflict of interest issues, note them, and then we can discuss them tomorrow during the debrief. And we will go over it tomorrow, and you can also ask any questions you have from today's session and tomorrow's. Thank you for your time. I look forward to working with you tomorrow, and we'll just take it from there. Thanks.
Thank you for your participation. That does conclude today's conference. You may disconnect at this time. Hey, this is Candy. I have your line.